Mr. Chairman, much as I don't like certain parts of the Mazur decision, it clearly applies in this case, and the committee is required to engage with the White House in order to seek an accommodation over materials held by a private party, as they were in the Mazur's case, and seek to resolve this with the White House. So I would ask unanimous consent that we enter into the record your correspondence to the White House.
Objection. Seeking
to engage them to resolve this. And I thank the chairman for not objecting. Can you produce that correspondence to the White House asking for accommodation on these materials you've sought by this subpoena?
First time they reached out to us was 2 days ago.
Yes, and of course the author expressed the concern that these materials may implicate interests of the executive. I think that was weeks ago. But having admitted without dissent your correspondence to the White House, can you produce that for us where you have sought an accommodation, where you've sought to work this out with the White House? Can you share that with us since that is now part of the record?
Well, I thought you had it. You wanted to enter it into the record.
I do. I presume that, knowing your responsibilities, you have sought to engage the White House. So,
Mr. Chairman, point of order.
Produce the
recognized for point of order.
Adam Schiff thought he had Jim Jordan cornered. Then the hearing flipped so fast it looked like a GPS recalculating in real time. Seriously, what started as a routine political attack suddenly turned into a debate about constitutional limits, executive privilege, and whether Congress actually followed the rules before threatening contempt proceedings.
A unanimous consent request to submit something to the record is where the person who's asking for the floor is the proponent of submitting information that member has. I don't believe it's appropriate to ask a unanimous consent request to engage in a colloquy over discovering information or obtaining information from another member of the committee.
Great, and that's why I said that no objection to the unanimous consent request. If the gentleman from California wants to talk about that and present it to us, God bless him. He's allowed to do it. So it's 5 minutes.
I would like clarification from the chairman. Does this mean that there is no correspondence from you to the White House seeking accommodation on this material?
We've had all kinds of correspondence with the White House on this broad subject relative to the Zwanitzer and the letter we got 2 days ago. We've not corresponded with the White House yet. If we will, we may. That's a decision we'll make.
And you have not corresponded with the White House seeking accommodation ever since the author who you are subpoenaing and seeking to hold in contempt articulated the view that there was executive interest and potential privilege over this material? You haven't sought to engage over the weeks since you received that communication?
We have not engaged with the White House since the letter on the 25th of this month, 2 days ago.
And prior to that time, did you engage the White House in an effort to obtain these materials?
All kinds of engagements with our counsel and counsel, both
I'm talking about
Justice Department and White House with our counsel over the last several months relative to the special counsel
this subpoena, Mr. Chairman. Did you engage with the White House at any time in the last several weeks since issuing this subpoena, the one you want to hold this witness in contempt for? Did you ever engage with the White House in an effort to accommodate, an effort to reach an agreement, an effort to prevent this from having to be litigated? Did you ever write any correspondence, make any call to the White House seeking to engage, seeking to get these materials that you're seeking from the author instead from the White House? Did you ever do that, Mr. Chairman?
We're seeking documents from a private individual who, I might add, tried to destroy the evidence.
I guess the question is, I guess the answer is no.
Since 2 days ago.
The answer is no.
The answer is since 2 days ago, I'm not
asking the question about since 2 days ago, although nothing prevented you.
That's when they first raised the concern.
Nothing prevented you from writing a letter within the last 2 days or reaching out to the White House before this.
Now you want me to be clairvoyant and read the White House's mind and write a letter before they tell us something?
Nothing prevented you from seeking these materials from the White House
is known for
months, Mr. Chairman. For months.
I'm not a mind reader.
And I thank you for making a very clean record for any court that will look at this.
The gentleman from North Carolina said
accommodation
months ago the White House could have raised the concern, and they didn't.
To obtain these documents, because your first move, of course, is to go right to contempt. Ironically, of course, for a chairman who was in contempt of his own subpoena.
Point of order, Mr. Chairman.
We're still waiting for you to testify and meet the obligations of your own subpoena, Mr. Chairman. But nevertheless, I appreciate you're making such a clean record for any court in this case You have never sought an accommodation, never written to the White House, never called the White House, never had a communication with the White House in order to obtain these materials as part of an accommodation. Thank you for that very clean record for the court, and I yield back.
Gentleman yields back. Who seeks recognition?
And wow, the more Schiff kept asking questions, the more uncomfortable the room got. All right, so here's the situation in simple terms. The committee wanted documents connected to a larger investigation, and Schiff argued that before Congress could move toward contempt, they first needed to engage with the White House because executive privilege concerns had already been raised. Now, I know executive privilege sounds like one of those phrases politicians throw around to confuse everybody, but the basic idea is actually pretty simple. The executive branch has certain constitutional protections when it comes to internal communications. Congress still has oversight powers, obviously, but courts usually expect both sides to at least try negotiating before turning everything into a legal battlefield. That's why Schiff kept referencing the Trump v. Mazars case. His point was basically this: even if the subpoena targeted a private individual, the documents could still involve executive branch interests. So, before threatening contempt, the committee should have at least tried negotiating first. And this is where the hearing started getting awkward, because Schiff kept asking one direct question over and over. Did the committee actually contact the White House before escalating this? And every answer somehow created even more questions. The interesting part here is that this stopped feeling like a normal political shouting match pretty quickly. Schiff kept pushing for proof that the committee had seriously tried to negotiate with the White House before moving toward enforcement. Not vague conversations, not assumptions, actual communication. And eventually, the chairman admitted there hadn't really been direct engagement with the White House on this specific issue until very recently. And that's where people started paying closer attention. Because whether you agree with Schiff politically or not, procedure matters. Constitutional limits matter. Due process matters. Conservatives have been talking about this for years. Government power is supposed to have guardrails. You don't skip steps because you're frustrated. You don't bypass constitutional process because you think your side is morally right. That's exactly how overreach starts. Now, the chairman tried defending the committee by saying the subpoena targeted a private individual, not the White House directly. Okay, fair argument on the surface, but Schiff's response was basically, if executive privilege still applies to the documents, then Congress still has a responsibility to attempt accommodation first. And honestly, courts usually care about that kind of thing. That's why Schiff kept repeating the phrase, clean record for the court. That wasn't random. He was setting up the idea that if this ends up in court, courts are probably going to ask whether Congress genuinely tried to resolve the dispute before jumping straight into contempt proceedings.
And based on the hearing, that answer didn't exactly sound great for the committee. What makes this whole thing interesting is the irony. For years, Americans have heard non-stop speeches about defending institutions and protecting democracy. But moments like this remind people that constitutional process matters too, especially when things get politically heated. The Constitution isn't just there for easy situations. It's there for the messy ones where people are tempted to cut corners. And honestly, once the public starts feeling like rules only apply sometimes, trust in government drops fast. And somewhere in the middle, the court reporter is probably sitting there thinking, could everybody please spell constitutional crisis one more time for the record? Subscribe to Congress Showdown, and I'll see you in the next one.